especially on their financial commitment, a plan that they're able or afford to pay, and also the benefits they expect to receive from a policy. Or for example, a very simple like Great Shield Active, we have 7 plans altogether, right? So if customers say that, well, I can only afford to purchase a plan one, and what will be the benefits? Yeah. So after explaining everything, if the customer is still comfortable, then that's it. Yeah. Then a deal done. Now, this is something that I want you to take note. Yeah. So to actually complete all the mandatory courses of e-learning, all right, and meet your CPD hours to maintain and your competency to fulfill the role and responsibilities of an agent. Especially this year, we have 6 e-learning. I will say the mandatory e-learning that you need to be completed. Yeah. As compared to last year, we're going to have 2 e-learning, which is actually the PDP and whistleblowing. All right, now, if you are unable to complete this 6 e-learning by the end of this year, your front end system will be blocked here to issue new cases. All right, remember, so it's very important to do it earlier, so to avoid any difficulties to actually go into the system on last minute basis. There could be technical issue, then your front end system will be blocked. Yeah. Now, for new agents, if there's any new agent join for these sessions, please complete your ETP, our onboarding training, as well as this mandatory e-learning, all right, within 6 months from the appointment date, right? Otherwise, the front end system again will be blocked if you fail to complete this 6 mandatory e-learning within half a year. And also be mindful that for those new agents that join us this year, because of a new guideline here, we call it PITA guideline, professionalism insurance takaful agents guideline. Yeah, you need to fulfill 12 CBDs. Yeah, from within half a year from your appointment date. Yeah. Now, ETP onboarding training already got 8 hours, right? So you need to actually just fulfill another 4 hours, be it attending training or rather by completing e-learning, right? Now, do not use customers' data without getting customers' consent. That's under the PDP Act 2010. That's very important. Obviously, if customer wanted to buy any insurance plan from an agent, yeah, of course, he will give a consent to release his personal information, yeah, to fill up the form, things like that, yeah, for the application purposes. Now, that consent is only for that application purposes and cannot be used for any other purposes, yeah. So in future, if you wanted to get another PA product, for example, yeah, you need to get another consent or the fresh consent from such a customer, all right, to proceed with the application form, all right. Now, do not induce customers to purchase or renew insurance products by misrepresentation or use any sales brochure or illustration not authorized by GEGM. That's under MSZ 2013. Yeah. For example, so we cannot be seen that because we wanted to have a higher commissions, then we actually push up a higher plan for the customers to purchase. So that's no. And lastly is actually do not exert undue influence or attract customers to purchase insurance products or in demanding insurance premium. That's under FSA 2013. So also it's prohibited. Yeah. I mean, casual talk with customers once a while, yeah, is fine, but we cannot be actually calling customers day and night, yeah, just because we wanted to close, such a case. All right. Now, so with this, I shall actually completed my reminder on market conduct essential. So I will pass over to Mala. Yeah. So Mala, over to you.
Thank you, Alex. A very good morning to everyone. Okay. For this morning, we will look at 3 products, basically 3 areas of liability. First, we'll do professional indemnity, and then we will look at product liability, and then we will do comprehensive general liability. During the session, if you have any questions, you can either unmute your mic and ask, or you can actually type it out in the chat box. Then Alex will read it out for everybody's benefit. Okay, so okay, let's start. First, we will do professional indemnity insurance. What we will look at is briefly the policy coverage. What are the main extensions, main exclusions? What are the policy conditions? And of course, the claims example, some claims examples for to share with you all. Okay. So I'm not sure whether all of you have heard this word before, professional indemnity insurance. So what is professional indemnity insurance? Okay. Now, you all know that today professionals are expected to be accountable for their services.
Sorry, Mala, you have not shared your slide uh, yet, right?
I oh okay, sorry. I
All
didn't
right.
share the slide. Oh, just now you took over, is it?
Just I have took over your screen. Yeah.
Okay, 1 minute. Sorry, folks. Okay. Okay now?
Yes, can see your slide. Uh, okay. We might see whether you're able to actually have, zoom up to the full screen. Already
Yeah,
zoom up, huh?
I have full
Or
screen
doesn't matter?
already.
Yeah, because I think. Oh yeah, I
Full
think
screen.
there's some.
Yeah,
uh, Yeah, there's a limitation. I can still see the multiple slides on your left side. Doesn't matter. You can carry on. I mean, this is something
can see,
to
right?
build with
Okay.
the
So this is the
setting.
agenda.
All right. Okay. Yeah.
Okay, then we go on to what is professional indemnity. As I was saying, professionals are expected to be accountable for their services. Okay, so basically, who are these professionals? There could be many. Okay, so this professional indemnity insurance is actually a type of liability policy sold to specific professionals, okay, such as engineers, lawyers, architects, surveyors, accountants, and the list is non-exhaustive. Okay, I just mentioned a few of the main ones here. Okay, so basically, professional indemnity insurance protects professionals against legal liability from third party claims in the event they are sued by any third party for whatever services that they have provided. Okay, so it covers professionals for claims made against them for breach of their professional duty. Okay, so who is a professional? Now, we all know that a professional is a person who has gone through the relevant education and training in respect of a particular profession or field of study. Okay, and these professionals must actually be governed by an association. Okay, it's just like, for example, the lawyers are governed by Malaysian Bar Council. Okay, doctors have got the MMC, Malaysian Medical Council. Okay, the engineers have got their own IEM and stuff like that. Okay, so each profession is actually governed. Okay, there is an organization or association governing them, governing their conduct. You know, if anybody needs, you have to sign up. Sorry, not you have to sign up, you have to register with the particular association before you can practice. Okay. I have listed here some examples for you under these are professionals under the construction industry, but there are many more. Okay, this list is non-exhaustive. So we can see here there are engineers, architects, land surveyors, quantity surveyors, interior designers, project managers. There are also town planners, um, many more lah. All right. So, yeah, other professionals other than the construction industry, there are management consultants, company secretary, accountants, auctioneer, real estate agents, lawyers, human resource consultants, marketing consultants. So you can see nowadays, it's really very, very diversified. Okay. And if you talk about the construction professionals under the construction industry. For example, engineers, there could be many variations of engineers specialized in civil structural, mechanical, electrical, chemical, environmental. So there are many, many types of engineers. Okay. So if you think that you have something in mind which is not in the list, maybe yeah, we can take a look at it as well. Okay. So why professional indemnity insurance? As I mentioned earlier, if a third party suffers a loss, okay, say you want to consult a lawyer, all right, so you go and make an appointment and go to the lawyer's office, you discuss something with him, ask him his opinion, and he provides consultation to you lah, and then he charges you a fee. Now, if you suffer a loss after relying on his advice, then you are entitled to sue him to recover the whatever damages that you have suffered. Okay. So this policy, when you sue the lawyer, this policy actually provides protection, comes in to defend, because if you send a legal letter to the lawyer, he has to defend himself, right? So what happens is this policy will come in to provide cover to defend the claim against the lawyer. So if a third party suffers a loss after relying on professional advice, they are entitled to recover their loss from the professionals. So basically, PI offers protection against errors or omissions committed in the conduct of insured's profession. Okay, so one very important thing here is that it must be, the error or omission must be committed in the conduct of insured's profession. It cannot be a situation where you after work, okay, after work, the lawyer goes and with a group of his friends start drinking and all that. Then the friend, in a friendly manner, asks him, "Hey, I need your advice, lah. On something." Then he asked him, and then the lawyer advised him. Then where he relies on that and goes and you know maybe suffers some loss. The one cannot lah. It's because it's social time. They are drinking. It's not a formal uh consultation where you pay a fee and stuff like that. Okay, so it must be related to the conduct of insured's profession. Okay, not on your own accord or social event and stuff like that. Okay, what does this policy pay for? Um, the professional indemnity policy indemnifies the insured for two things: if there's any act of error or omission due to breach of professional duty, or and also legal costs and expenses in defending the claim. Like I said, if there's a writ of summons served or there's a letter of demand and the lawyer has to reply, then GE will appoint the lawyer and get the lawyer to respond to the third party's legal letter, right? So this incur cost. The lawyer is not going to do it for you free of charge. So this is where the policy comes in to pick up the legal costs and expenses. So basically the total amount for the breach of professional duty or the compensation and legal costs and expenses, the maximum the policy will pay is up to the full policy limit stated on the schedule. So if you buy a policy for 1 million, then the limit will be 1 million. Okay, they will pay up to 1 million. Okay, let's look at some extensions under the policy. These are basically standard extensions already factored into the policy. So usually there's no additional premium charge. Libel slander. If a professional, for example, in the conduct of his work or whatever it is, says something defamatory, okay, against another person. So
Sorry,
if
Pakar
the
Kumala.
the other person or the third party comes to know about it, he may decide to sue, right? The person who actually mention the defamatory words. Okay. So in this scenario, the policy will come in, okay, to respond to the claim.
Mala, so if I know an option,
Yes.
the slide doesn't move. It's still on. The slide doesn't move. It's still on page 6.
6. Wow.
Now it's 12 already. Yeah. Now
Now
you
can see.
just
Okay,
skip
then I
down.
don't
You
use
can see.
the full screen lah. I think better like this. Then you all
Yeah,
can
lah.
see.
Yeah.
I don't use the full screen
Okay.
like
All
the
right.
other day. Okay.
Cool. Yeah.
Okay. Thanks.
Yeah.
Yeah. Sorry about that, folks. Please let us know if the screen doesn't move. If you see me listening to me talking about something else, then I think if it's not on the screen, just let us know. Okay. Loss of documents. All right. Now, loss of documents. Basically, I'm not. This is a very old. Like insurance wording is all very old normally. So loss of documents is a cover that has been given many over the years. Many years ago they have given this. Nowadays, with computers and all that, people don't use paper anymore. Very, very less use of paper. So this loss of documents actually covers, it pays for cost of reconstruction of the documents to replace it. Okay, if the documents are lost. Things like wear and tear and all that is not covered. If the document is eaten up by vermin or those insects that eat paper, or it's faded, that's not covered also. So it's basically for documents that have been lost. But nowadays, why I say this cover, I'm not sure how effective it is nowadays because most of it is stored in computer. You can, like, for example, your medical records, your what else? All the engineers, their maps and stuff like that. It's all stored in computer. Okay, so actually, at the press of a button, you can reprint the documents or you can get another copy. So this may not be very effective lah today. Okay, this cover. Nevertheless, it's still given. Okay. Dishonesty of employees. Yeah, if the employees have been dishonest or whatever it is, then yes, we cover that claim. However, please take note, loss of money. Okay, loss of money, cash is not covered because there is a separate cover if your employee steals money from you, which is, I'm sure you're well aware which policy, fidelity guarantee. Okay, so that's the policy that is basically you have to recover from lah if it's cash. Okay, next, consultants, subcontractors and agents. Now, this one, the policy actually covers claims made against the insured arising out of any act or error committed by a contractor or subcontractor engaged by the insured. Okay, let me explain. I think it's a bit confusing. Now, you have a situation, assuming it's a project risk, okay, construction project. So there will be a main con, right? The principal will sure engage a main con. Now, the main con may be an engineer, but he cannot do everything in a project. Let's say he's constructing any building, he will have to do, maybe, okay, like he's a civil structural engineer lah. All right. Now he may not have the expertise to do the mechanical electrical work, so he may need to engage a subcon, okay, who's expert in electrical works. So when he engages this subcon, the subcon does the job. Say the subcon makes an error, commits an error. Okay, you all know, I'm sure, in a construction claim, usually involving many parties, okay, when um and when they sue, they will sue everybody, okay, anybody and everybody, just to ensure, because at the onset, okay, on the face of it, when there's a claim, there's an event that occurs, okay, you won't know who is at fault because there's so many parties. You got the geotechnical engineer, you got the civil structural, mechanical, and you have the contractors. So you don't know who is at fault. okay, when a claim actually happens, until you investigate and you really go to the root cause. So that may take time. So as to not leave out anyone, they will just sue everybody. Okay. So in this kind of a scenario where the main con has engaged a subcon to do the electrical works and the subcon makes an error, now the main con also will be sued in the rate. So what will happen is this policy will respond to defend the main con. Okay. But this policy will not cover the subcon. Remember, for PI, okay, PI insurance to trigger, the policy will only cover the insured named under the policy. Most liability policies are like that. Your PL also same one, right? Your PL, I'm sure you're familiar with PL. So it will only cover the insured named under the policy. They will only cover that particular insured. So you've got two insureds, then of course will cover both lah, you know. Now, joint venture liability. Joint venture liability is like sometimes there's a mega project. So the principal can't just appoint one consultant. They need more than one. Okay, so they will engage two firms, maybe two large firms, because those two firms got expertise in certain areas. So the project can be done. Okay. So what will happen is when they have JV, okay, Company A and Company B joint venture. Company A has their own policy, Company B has their own policy. Now, if any employees of Company A commit an error, then the Company A policy will cover. Okay. If Company B employee commits an error, tries to recover from Company A, the policy won't cover. Okay, so they will have to seek indemnity from their own policies. However, having said that, if there is a JV, I'm sure they will have to buy a single policy. That means there will be two names, like I told you earlier. There will be two names, and then we will put their JV. So both are covered under one policy. Okay, usually that's what happens lah. They won't be expected to buy separate policies. But those small projects that you see, usually the annual policy will be sufficient lah. It's only for those huge projects you will see that consultants need to buy a standalone project PI policy. Their annual policy, they cannot use the annual policy because the limit, the duration, all is different. I will come to that later. Okay, I will explain that later. So as we move on the limit of indemnity, as I said, the limit of indemnity, the maximum amount the policy will pay will be stated on the schedule. Okay. Now, the policy will pay for the claim or compensation and legal costs and expenses in defending or settlement of the claim. Okay, we are now on slide 14. Any questions so far before we move on? Any questions? Alex, it's on 14, correct?
Yes, correct.
Yes, okay, all right. No questions, Alex, so I move on.
Yeah, you can move on.
Okay, next, this is important. Claims made basis policy. I'm not sure how many of you have heard this. Claims made basis versus occurrence. The other form of policy is occurrence basis. Let me explain the easier one, which is occurrence, that is familiar to all of us. Let's take your motor policy, your fire policy, even your public liability policy. Okay, all these policies are written on occurrence basis. When I say occurrence basis, what I mean is that when a claim is made, let's take an example. Say you met with an accident last year in November. Okay, were hospitalized and all that, so you couldn't lodge a claim. Now today, you're fine. Your car's still in the workshop because you didn't drive it. Okay, you were in hospital and all that, so you call GE claims people, claims department. Hey, I want to lodge a claim. Okay, my vehicle was involved in an accident. So okay, the person will actually take note of your claim and register it under your policy last year because you had a valid policy from January to December 2023, right? So they will register the claim under last year's policy in November. No issue, right? Fire same, your public liability also same, all your other policies occurrence basis will be the same because as long as you have a valid policy, right, and the incident happened during that time, it does not matter. Of course there's conditions lah, you have to report a claim within reasonable time frame, okay, but insurers will not reject your claim lah. Okay, even if there's a delay and you have a valid reason why there was a delay. Okay. However, for claims made basis policy, that one is occurrence, remember. Now, for claims made basis policies, it's a bit different. Claims made basis policies, all these policies have a retroactive date. Okay, I'm not sure how many of you actually would sell liability policies. If you have, then you will know, you would have seen this word on the policy, retroactive date. Okay, now on a claims made basis policy, any act or error committed after the retroactive date stated on the schedule, it will be stated on the schedule. Okay, committed after the retroactive date will be covered. Okay, usually the policy will cover any act or error committed after the retroactive date. If the act or error is committed prior or before the retroactive date, the policy will not cover. For example, if your retroactive date on a policy is first 2023, okay, any act or error after that date will be covered. So if you have an incident which happened in June 2020, this will not be covered under the policy because it's before the retroactive date. Insurers will decline the claim and tell you, hey, Mr. T, this incident happened, you know, before, so no cover. Okay. Now, the policy is on a claims made basis. That is, claims made against the insured and notified to the insurer during the policy period. So, very important, policy is on claims made basis means that the claim is made against the insured and notified to the insurer during the policy period. That means you must have a valid policy in order to report a claim. Let's look at an example. I know it's not easy to understand. It's a bit complicated, right? Let's look at an example. Then perhaps it will be easier for you to understand what I'm trying to tell you. Okay? Okay. Example, policy period is first 2023. Same example like your motor policy just now. Okay. The retroactive date on the policy says it's first 2020. The circumstance or claim is made against the insured in December 2023. Okay. Now, insured reports the claim to the agent and the insurer. So, no problem lah. Okay, because the retroactive date first 2020, there was a claim made against the insured in December 2023. They got a valid policy. So immediately in December, the insured reports to the agent or insurer, and the insurer registers the claim. GE registers the claim under 2023 policy. No problem. Okay. Now, next scenario. Same situation, policy period last year, 2023, January to December. Everything is the same. Claim made against the insured also, letter of demand in December 2023. Now, claim is not reported to agent. Assuming clients, insured's personnel who handles all this, okay, say resigns. So you know when people resign, then somebody new comes and takes over. There's sometimes shortcomings So the claim was not reported to the insurer. Now in December, the policy lapsed. 31st December, policy lapsed. Okay, they didn't renew their policy. Now in February 2024, there was a writ of summons filed. So there is no cover. If you go and report to GE will tell you, I'm very sorry, but there is no cover. So you see the difference between occurrence basis policy and claims made basis policy. So take note, for occurrence basis, as long as you have a valid policy when the incident happened, okay, it does not matter when you report. But for claims made basis, you must have a valid policy to report a claim, plus the act or error must have been committed after the retroactive date. Very important. So please make sure that when you are dealing with liability policies, you have to highlight this to your client. Okay? Because sometimes we note that clients tend not to report claims because they feel that if I report claim, I'm sure the insurer will load my premium next year. But think about it, which would you rather have? Load the premium, or you want to handle the claim yourself, right? So continuity in insurance coverage is very important. Make sure when you change insurer, for example, say you are with GE this year, next year you want to change to Allianz, okay? Make sure the insurer gives you back the retroactive cover. So if there's no gap in the insurance cover, that means you continuously have been renewing your insurance, okay? Even when you change insurer, they should grant you the same retroactive date. Okay, please take note of this. This is very important. So don't just take it lightly if there's a claim. Okay, you must tell your client to report. Okay. Next. If you still not very sure, don't worry lah. When we go through the product liability, I will explain again. Okay, no worries. Okay, now we have finished the extensions, then we went through claims made. Now let's look at what are the main policy conditions. Okay, now first of all, right, I'm saying claims. Some of you may wonder lah, for liability, because property, motor, and all, you all know how it works. You are claiming under the policy, it's a first party policy, correct? But for liability, the claims are always from third parties. Okay, so claim can arise in the way of a writ of summons, a letter of demand, okay, statement of claim. There are many ways, okay, counterclaim. There are many ways a claim may arise. So most of the time we advise our clients not to admit liability or settle any claims without the insurer's consent, because once you admit liability, when I say admit liability, that means if there's something that happens, people get very angry. Okay, people start shouting lah, scolding lah, all this, right? So it makes the whole situation is turns very ugly and very tensed, right? So sometimes um people also get worried. Then they say, yeah, 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 accidentally in fear and all that, they might say, yeah, 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 it's my fault, it's my fault, I accept like it's my fault. You shouldn't say that, because once you admit liability, okay, what are we going to defend? How are we going to defend you? You already say you are at fault, then how to defend you, right? And this will prejudice not only your rights, but insurers' rights as well. This is one of the policy conditions. Do not admit liability. Okay? Because your rights are prejudiced, and you also prejudice the insurance company's rights. And please advise your clients not to settle any claims without insurer's consent, because liability claims, there's no limit. Okay? The sky is the limit. I want to claim 5 million, 10 million, up to me lah. Whether I succeed or not is another thing. Okay, so initially you may think, this one not very big claim lah, small claim only. But as you progress, you may be surprised. The claim may escalate. So be careful. Try not to admit or settle any claim without insurer's consent. Okay, and I repeat again, please notify all claims promptly to the insurer. Okay, not only claims but circumstance as well. Now, what do I mean by circumstance? Circumstance means you know already something has happened, something has gone wrong, and potentially there will be a claim. Potentially in the future, okay, there will be a claim, but you already know this, but you don't report. Because I worry lah, after GE will increase, the underwriter will increase my premium. You see, you look at your policy, any liability policy, they define a claim as claim of circumstance known to the insured. Okay, so this is a circumstance. Something you know that has gone wrong. You must report it as a potential circumstance. You must tell the insurer, yes, there's no third party claim yet, but this has happened. So we will actually register it and keep the file open. So next time, if any read or whatever comes up, right, we will handle it. We got records. Okay, rather than you don't report anything, you just keep quiet, can be very dangerous. Financially can be crippling. Okay, because when you're faced with a claim, you don't only have to pay the compensation, you may have to also engage a lawyer. And to be very honest, legal cost nowadays is also escalating. It's not cheap to engage a lawyer and defend. Okay. Okay, like any other insurance policies, this policy also has exclusions. Any prior known claim or circumstance. You see, I mentioned just now, explain what is a circumstance. So any prior known claims or circumstance which maybe you have reported under your previous policy, to another insurer, we will not cover it under this policy, the current policy. Okay. Dishonest, fraudulent, criminal, and deliberate acts will not be covered. We only cover accidental and unintentional acts. Okay. Claims by related or associated entity. Now, what do I mean by this? Claims by related or associated entity. Let's look at an example. Say you have a holding company and you have subsidiaries right under the holding company. Say one of the subsidiaries buys a PI policy, for example, and the holding company sues the subsidiary. Now, By way of this exclusion, okay, the claim will not be payable because they are a related entity. Okay, when I say related subsidiary, parent holding company, sure can twist the arm of the subsidiary, right? They got control. So we will not entertain any claims of this nature. Okay, fines and penalties will not be covered. Why? Because it is against public policy to pay any fines or penalties in Malaysia. Okay, it's just like your motor policy. You are fined by the summoned by for traffic offense, all this, right? You claim it under your motor policy? Cannot, right? So similarly, even under liability, if a fine or penalty is imposed, the policy will not reimburse this. Okay, goods manufactured products liability will not be covered. Why? Because there is another liability policy that covers this type of exposure. So the professional indemnity policy will not cover this. Professional indemnity will only cover the any breach of professional services. Okay. Trading debts, whatever debt, say lah, somebody owe you money, your client didn't pay you your fee or whatever for the service that you have done. This one will not be covered. Okay, under the policy, you cannot claim reimbursement under the policy. Services not performed for the firm. Remember, just now I mentioned it must be whatever service, whatever claim that results, must be something that you have any act or error that you have committed in the conduct of your profession, correct? So, say I'm working for an engineering company and I also do some freelance consultation lah. Okay, freelance meaning for others, okay, other companies. Now, if there's a claim made against me when I do my freelance work, I cannot claim indemnity under this policy. Okay, because it will not cover. The policy will only cover me for that work I do for firm A. Okay, whatever freelance work that I have been doing will not be covered under the policy. Okay, and of course, war, terrorism, the one I won't explain now. You all know what it is. These are standard exclusions in all policies. Okay, now just a very quick comparison between two main types of PI policies. The first is, we all know the annual policies lah, okay, 12 months policy. The 12 months policy will cover all your activities, all the interest activities, which means for the 12 months, whatever jobs, whatever projects you undertake, all this will be covered. You don't have to declare to us. Okay? Now, it's written on an annual basis. Okay? Now, for specific project, this is SPPI. Okay, single project professional indemnity. Okay, now this policy is very different from an annual PI policy. The SPPI policy only covers one particular project. So you will be the principal will require you to buy this policy when it's a huge project. Okay, and there are many parties involved. So it covers one single project, and the policy is usually tailor-made, okay, to meet contractual requirement. You will see in the letter of award, usually, right? It will mention what is the limit you need to buy, and also the number of years, including the maintenance period. So it could be 5 plus 2, 3 plus 2, or 3 plus 3, whatever it is, combination. Okay, so usually we can issue a single policy for the limit, the contractual limit that is required, and for 5 years or 3 years or whatever it is, or 7 years, whatever it is. Okay, because it has to comply with the contractual requirement. Usually, right, these are the PI cost, the cost of insurance, okay, can be factored into the tender. So the principal will pay the cost lah usually for the insurance. Okay, so that's the difference between an annual policy and a single project policy. Okay, we also do single project. So if you have, you can actually refer to us. Now, this is, I'm sure you all come across this type of questions lah from your clients. Hiya, Mr. Agent, I never bought insurance before. So I don't know lah, my company, how much you think I should buy? Let me forewarn you, friend, okay, agents, please do not recommend a limit. As I said, the sky is the limit when people want to sue you, okay? So your answer should be, Mr. Client, well, I'm sure you also have, limit is one thing. You are the best judge of your exposure in your company, right? So we can give you options. And I'm sure you also got budget for insurance. You would have allocated some budget. So we give you the options. Never mind 1 million, 2 million, 3 million. First time buyer, right? So they may not want to buy a very high limit. But please don't suggest lah. Oh, you buy 1 million lah, enough. May not be. The guy will come after you after that when there's a claim and he finds the limit is insufficient. So you tell them that you can give them options, okay? And it depends, okay, on the risk exposure of the company. A small company, I think 500,000 also enough. No need to buy such a big limit, okay? Then of course, if it's if it's a project, then of course there's a requirement by the principals, okay, in the LA, and then depends on their budget, how much allocation they have for insurance. So this is the underwriting information that we normally require before we can come up with a quotation. Okay, for annual PI, okay, before that, if you are attacking an account and you're unable to give us a recent, say, this year's proposal formula that the client has completed, if possible, please let us have last year's proposal form. At least we know what is the client doing. You know, how many years of experience do they have? All right. And also if there's have been any claims. Okay. If not, sometimes, most often, we receive a expiring policy. Underwriter, please give me quotation. I'm sorry to say lah, but please put yourself in our situation. What does the policy, what information does the policy give me? I know who's the insured, I know what limit they buy, I know what premium, I know what excess, and what are the terms and conditions. Other than that, nothing, no other information. So how do you expect? What's the size of the business? How many partners? What is their turnover? All this sometimes is not stated in the policy. So really, how to come up with a quotation? You tell me. So this is the challenge. Please understand, we are not being difficult. This is the challenge faced by underwriters. If you don't give us enough information, at least the bare minimum lah. If you cannot give me proposal form, tell me what profession, what's the name of the insured, fee income, what limit, what's the claims experience. So at least we know. We can give you something called a indicative quote. Okay, indicative quote subject to review upon receipt of completed proposal form. Okay, so please remember this. We need some cooperation from everybody also. Please don't send us policy wording, policy and ask us to quote. It is really very tough. Okay. Now, for single project PI, normally you won't have information lah. I know. I mean information as in letter of award. Okay, because if it's a tender, you will only get it once the tender is awarded. Okay, so you can give us things like if you're participating in the tender, you will know what's the limit they require. You will know some information lah, like contract value, fee, what's the period of cover, what's the scope of works that you're supposed to do. So you can actually share this information with us. Then we can give you a non-binding, a rough indication, a very, very rough indication of what the premium would be like. Okay. Then from there, once you receive the letter of award, then you can forward it to us. Then we will fine tune the pricing or the terms. Okay. So we are almost coming to the end of the professional indemnity training. Why buy liability cover? Imagine if you don't have insurance. All right. Now, with insurance, of course, the policy you can sleep easy lah. The policy will pay if you are sued, okay, for legal costs or whatever it is, and you don't have to take out your own money, right, to pay for whatever policy pays. So you have peace of mind. And then usually insurance companies for liability claims, they will try to handle it quickly in order to prevent any adverse publicity against the insured. Okay. So if you don't have insurance, what can happen? You could suffer loss of reputation because you don't have funds to engage lawyer. All this judgment can be taken against you, right? So eventually your reputation at stake. Then it could be a situation you don't have enough money, your business also not doing well, so you lose your personal assets because you have to fund the claim, the litigation costs. All these are expensive, huh? Then you also suffer loss of business eventually. Okay, so this is the danger. Okay, let's look at some claims examples. Examples just intend to give you all an idea, better understanding lah, okay, how the claims can come in. This is you see the picture there? It's collapse of roofs on a row of shop houses. This is a real incident which happened in Singapore. Okay, apparently a row of shop houses had a fancy roof lah. Okay, the roof was actually designed by an architect. Then the engineer did the structural designs. Okay, and the shop lots were built. Now, one day in a heavy downpour, the roof actually collapsed. You see, the architect here just did the design. Okay, I told you just earlier on that normally in a construction claim, they will name everybody, right? So the architect was named in the suit. But however, in this claim, who did the structural design? The engineer, right? So most likely the claim will be the engineer will be found to be liable lah, in this situation because he's the one responsible for the structure of the building. The architect merely did the fancy roof only so that it looks beautiful lah, that's all. So this claim was worth about hundreds of thousands. It was quite a big claim. Then counterclaims made by third parties, okay, alleging breach of professional duties to avoid payment of outstanding fees. Now, this one is usually a tactic lah. Okay, they want to delay payment. So if the principal engages a consultant, they don't pay you. Okay, there's a delay. Maybe their money stuck somewhere lah. Not that they don't want to pay you, but maybe the money is stuck somewhere, so they delay in payment, then you sue them lah. The consultant will sue them for the payment. Then the developer will counterclaim and say that, hey, you didn't do a good job. So this is basically usually this kind of claims got no merits lah, because really it's delaying tactics usually. Okay, so we see this happening sometimes. This one also you got to report. Okay, this one, collapse of retaining wall in a housing project due to design failure. Okay, you see, it's just a retaining wall, but can cost so much, 500,000. Okay, this one also probably is a design failure, so maybe the engineer will have to pay lah out of his policy. Okay. Here are some examples involving other categories of professionals, like accountant. Okay, client relies on accountant's incorrect tax advice, then they get fined by tax office. Okay, real estate agent. Real estate agent does not inspect client's rental property and the tenants damage it. Okay, so the owner can sue the real estate agent if they have gone through and used the real estate agent. Surveyor, wrong measurement or wrong calculation. Surveyor sometimes they can, when they before they construct anything on a piece of land, they will get the land surveyors to go and do measurement or pegging of the land, they call it. That means they will go and mark the land lah. You can see sometimes vacant land you can see like they have marked. They have like put some markings on the land to denote the boundary. Okay, so they will measure. So if you measure wrongly, then you encroach into somebody else's land and do the pegging and they start building, the neighboring landowner can sue you for it because you encroached onto their land. Okay. Solicitor, error in sale purchase agreement, fails to register patent or protect invention, or any allegation of fraud. So these are some of the examples as to how other professions can be sued. Okay, that's the end of the first session, professional indemnity. Any questions? Any questions, Alex, from anyone? Hello? Alex, can you hear me or not? Hello?
Mala, can hear you. So far, no question.
No question, okay, thank you. Can we move on to the next session then? Yeah. Okay. The next session is on product liability. Maybe this is a little bit more easier to understand because you are selling a product. It's easier to relate. Okay. Product liability insurance. We will be looking at policy coverage, extensions, what are the main exclusions, principal conditions, then we look at some claims examples. Today, in today's world, even in Malaysia, right, we live in a very litigious society. Last time in Malaysia, many, many years, say 20, 30 years ago, people don't sue, okay? okay lah, they just accept whatever and go on. But today, we live in a litigious society where almost anything can threaten your small business. If you're a small businessman, right, even a small claimer can really cripple you because you don't have a lot of uh, cash to advance usually, right? So even a small claim can even cripple you. Now, why do we have or why do we need to buy products liability cover? Products liability basically covers the manufacturer or the seller who is held responsible for placing a defective product into the hands of a consumer. Okay. So today, if somebody buys something which is defective and the product actually causes bodily injury or property damage to a third party, okay, the consumers are very aware of their rights. Okay, so they will sue you. So this is one of the reasons. Excuse me, can somebody has not muted their mics? I'd appreciate if you mute the mic, please. Okay, so the reason the reason why you need product liability insurance is because firstly, consumers are very aware of their rights. Sometimes if you want to export your products overseas, then your overseas customer may may require you under the contract. And excuse me, can you all mute your mics, please? Please don't disrupt the training. Thank you. So it could be a requirement under contract. So this becomes a necessary cover. Okay. And then of course, peace of mind. Okay, because you know you have insurance. So if anybody sues you with regards to defect in your products, you know that you will be defended by the insurance company. So this is something that is brings you peace of mind. Okay. Now, product liability. What is product liability? It's the area of law in which manufacturer, distributors, suppliers are held responsible for any injury or property damage that a product can cause them. Okay. Now, as a consumer, right, you have every right to receive compensation if you buy a product which has, say, a misleading description or poor quality or makes you injured, okay, or you suffer property damage, okay, those kind of things. So you can sue the seller or the manufacturer for products that cause harm. Okay. Now, this can be in relation to um, goods that have been sold to any third party. Okay, a manufacturer may be held liable for bodily injury or damage to property belonging to a third party caused by a defective product. What is a product? It's a tangible property. Okay, it is something that is manufactured, sold, distributed, or supplied by the insured or others acting on his behalf. That means everybody in the supply chain, from the manufacturer to the end retailer, okay, everybody in the chain of sales must have product liability insurance, even if you're supplier, distributor, whoever. And this policy, coverage only takes effect after the product has left the insured's possession. That means if your product is still in the warehouse, then the insured finds something wrong with it, some formula, say it's shampoo, for example. They find something wrong with the formula. So as a result, the product does not conform to the actual specification. So it's defective. So what will happen? In the warehouse, then only they discover it. They cannot sue, they cannot claim under the policy. That is their own damage, because what does the product liability cover? Third party bodily injury or property damage. So this insurance only takes effect after the goods have left the insured's warehouse or possession. That means it's already being sold. Okay, the goods must be already being sold in the market. And somebody must buy it and suffer injury. Okay, only then the policy will trigger. Okay, so liability extends to everyone in the chain of distribution, from the manufacturer to the retailer. Anyone who has touched or handled the product from the initial stage, that means from the initial making of the product or the component until the product is sold to the end customer. For example, sometimes manufacturer may not make the whole product, like handphones, for example. Okay, they got parts, right? So there could be somebody making one of the parts, and then they sell it to the end manufacturer, who finally puts everything together and makes the final phone. Okay, so it could be a component also, right? Sometimes if you label the product wrongly, okay, like for example, the product contains nuts. Some people are very allergic to nuts. They cannot take nuts. So if you don't, when you label your packaging, if you don't, in the ingredients there, you don't indicate that it contains nuts, somebody who's allergic to nuts buys it and eats it and suffers allergic reaction, they can sue under the policy. They can sue you under the policy. Okay. And also, sometimes, like example, if you are a pharma company, drug manufacturer, medicine, okay, if you don't specify what are the side effects or allergic, okay, sometimes people taking multiple medication, it can cause very serious side effects, okay, and may result in a claim. So, yeah, this is also important. Okay. So defects in products can cause injury or damage to third parties and can expose insureds to a claim. Now, it can also be a situation, as I said, incorrect labeling, okay, wrongful instruction. Okay, nowadays, when we buy products, we can buy either uh, online, or we can buy in a shop, in a retail shop, right? So don't think that things you buy online, sometimes, say you buy a chair lah, okay, online, office chair, because you work from home now, 2 days a week or 3 days a week, so I need a comfortable chair, okay, you buy a chair. Now, they don't give you proper instructions to assemble the chair. So never mind lah, I know roughly how to assemble lah, So I buy online already, I sit and assemble it. Then I'm very happy because now I got comfortable chair. Wow, new chair, comfortable chair. I sit on it, and what happens? It collapses, and I suffer injury. I sprain my back. Okay. Now, can you sue the company? Yes, you can, because they didn't provide you with proper instruction to handle it, to install the whole thing yourself, right? Sometimes the instruction very vague, right? So you must be careful when you buy these kind of things online and assemble it yourself. Please be careful. Okay. Inadequate warnings. Inadequate warnings can be like, for example, okay, children's toys. Okay, you will see if you go to the toy stores, most of the toys got age limits, right? Not suitable for children under the age of 3. So if you look at those toys, normally under age of 3, 5, all these, the parts are very small, right? I don't know whether you all have seen the building sets. I'm sure you have lah. Building sets with the nut, screw, bolts, all these, right? These are all very small parts. So usually they got warning signs. This is what are called warning signs. You have to display this, because if somebody buys it, go and give a 3-year-old to play with all this, what would the kid do? They will put it in the mouth and they can swallow and choke on it. So it's very important. You must have adequate warning on your packaging. Okay. Defective packing materials. Say lah, the packing material is not of good quality, it's of low quality. What can happen in the by the time you pack, by the time you distribute and the thing is sold in the market, the packaging tak boleh tahan, got holes. What will happen? Air goes in, the food gets spoiled, can be moldy, worms can go in, baby cockroach also can go in. So people will start suing you because of the defective packaging material. So these are the type of claims that can arise under a product liability policy. Okay. So again, incorrect labeling, wrongful instruction, inadequate warnings, or defective packaging material. So these are the few examples that how a claim can arise under product liability. Who needs product liability? Now, as I said earlier, everyone in the supply chain, from manufacturers to distributors, wholesalers, retailers, and also those in the food industry. What do they need to prove? Have you ever thought about it? The claimant, most of the time, right, these manufacturers, they are aware of their responsibility, and duties regarding product labeling. If they fail, what will happen? If they fail to label properly, what will happen? And then the claimants actually need to show two things only: that the product is defective, and the defect existed when the product left the manufacturer or sellers or distributors place. That's all only. And then you must show that there was a duty of care owed by the manufacturer. The duty was breached by supplying a defective product and it caused injury or property damage. Okay. Okay, what does the limit? Now for product liability also, there is a limit which is stated on the schedule. The maximum the policy will pay for compensation, that means for bodily injury or property damage, and costs and expenses in defending a claim. The maximum the policy will pay is the limit stated on the schedule. So if it's 1 million, then the policy will pay maximum 1 million. 5 million, the policy will pay maximum 5 million. Okay. Again, we come to the complicated part. Remember occurrence basis and claims made basis? Product liability is also written on a claims made basis. Okay? Just like, actually, apart from public liability, other than public liability, which is on occurrence basis, all other liability policies are written on a claims made basis. Okay, so your professional indemnity, your product liability, your directors and officers liability, comprehensive general liability, all written on a claims made basis. But comprehensive general liability, some can do occurrence basis as well. Okay, so take note of this. Most other than your public liability and some comprehensive general liability policies, all other liability policies are on claims made basis. Okay. So, what are the features of a claims made basis policy? Remember, retroactive date. Okay, there's always a retroactive date on a claims made policy. The policy covers any act or error committed after the retroactive date, and the claim must be made and reported to the insurer during the policy period. Okay. Now, claims made policy. So, act or error committed after the retroactive date. Policy is on claims made basis, that is, the claims made against the insured and notified to the insurer during the policy period. Okay, I'm repeating this because I hope all of you can follow. It's just like a reminder from what we did just now on the professional indemnity. It's the same thing. Now, policy pays for damages or compensation in respect of bodily injury and property damage, legal costs and expenses in defending the claim. Now, example of claims made policy. Period of cover is 1/1/2023 to 31/12/2023. Claim made in September 2023. Reported to insurer in 2023 September and insurer registers the claim. Now, second example, claim made against insured in September 2023. They did not notify the insurer. They forgot to renew the policy in January. Then in March 2024, insured received a writ of summons. There is no cover. Okay, so remember, you must have, for claims made basis policies, you must have a valid policy to report a claim. Any questions? No questions? Okay, then we move on. Let's look at some of the main exclusions. Injuries to employees. Now, injury to insured employees will not be covered. Why? Because you have employer's liability or WC cover, right? So, injury to insured employees will not be covered under this policy. Okay, this is a third party liability policy. Product recall expenses. Now, a product liability policy can have a recall expense extension. Okay, but it will tell you the policy will tell you that there's a recall expense extension. If there isn't, most products liability policy don't have okay, so you have to request. This is additional cover, this is not automatic cover. Okay, recall is on top of your normal product liability. Usually a sub limit will be given for product recall expenses. There's actually two types of, when you talk about recall, I'm not sure how many of you are aware, but product recall, okay, basically those goods that are already in the market, that means it's been circulated, sold in the market already, then they find something, one or two customers have bought it, okay, and used it or consumed it, then it's found to be faulty, they suffer injury or whatsoever. So because of that, they have to recall the product from the market. Okay, they have to recall the product from the market. So you can either have a standalone recall or a recall expense policy. Recall expense policy is very limited in cover compared to a standalone recall. Okay, that's the difference. So normal product liability don't have product recall expenses. You have to add on, request for it. Okay. Warranties and guarantees. Oh yeah, recall. Do you all remember a few years ago, I think the Honda cars, they used to, if you drive a Honda car, you would have received a phone call from the Honda dealer to say, Madam, can you come in, or Mister, can you please come in? Bring your car in. You need to change your airbag for you free of charge. This is because there were some incidences overseas whereby the airbags were found of certain models were found to be faulty in an accident. That's why they had to recall and change the airbags for free. So can you imagine the cost incurred? Very costly, recall, not cheap. Okay. Now, warranties and guarantees. Warranties, guarantees, all this not covered under product liability because these are separate covers. Usually it comes with the product. They give you a warranty for the product for 1 year, 2 years, that kind of thing. Damage to the product itself. Now, any damage, right, to the product itself is not covered. Let me give you an example. I get a microwave from a retail shop. I take it home. I want to bake a cake. Okay. So I quickly go home, make the mixture, put it into the microwave to bake. All right. And I'm standing nearby watching because I'm so excited. Finally, I get to bake a cake on my own in a microwave. So suddenly there's an explosion after 5 minutes of usage of the microwave. And what happens? I was standing quite near. So my finger got burnt. My wall tiles, because of the explosion, the impact caused my wall tiles to crack. And of course, the microwave cannot be used anymore. Okay. So my finger, the burn mark to my finger, I can claim, right? Property damage to my tiles, I can claim. It's caused by the defective product, right? But damage to microwave, of course, I cannot claim under the policy. Okay, policy won't cover that. So this is what we say, damage to the product itself will not be covered. Okay. Latex allergy exclusion. Now, this allergy exclusion is used when we are writing or covering rubber products, rubber gloves, and all those things. Because latex can cause, some people are allergic to latex. So usually when you use those gloves, can come up with rashes. Okay. Failure to perform, not covered. Financial loss, not covered. And professional negligence. Okay, professional negligence, it's not covered under product liability. Why? Because there is a separate liability policy to cover this. Professional indemnity, which we just looked at this morning. Okay. Okay. Now, product liability. What are the defenses available? Usually, when you want to sue the manufacturer or the what do you call it? The retailer or whoever it is, like the wholesaler or whatever, right? They will use this, in their favor. These are called defenses available. Okay. If you didn't use the product properly, that means you maybe didn't use it for the purpose that it's being manufactured. Example, you already see a can. See the picture there, the can is dented already. You know this can is dented. Don't use it, because inside, you don't know how long it's been dented already. Could be karat inside. Okay, so why you want to drink something out of a dented container? Try not to. Okay, look at the baby stroller. This one is classic, because whenever you go to any supermarket, right, you look at people pushing the baby stroller. They have all kinds of things on the stroller. Shopping bag lah, food lah, whatever it is, they hang it on the baby stroller. Come on, this is to carry the baby, not to carry your shopping. What if it gives way? It's too heavy, right? So this is called misuse. You're not using the product properly. A stroller you're using to carry, like a cart, to carry things, not the baby. Okay? Then if you buy a product and you alter or you modify it, say I buy something lah, then I want to modify it lah. Okay, so I modify. And then you use it and it causes injury. Okay, this will not be covered because you have modified it. The manufacturer will claim that, hey, this is not the original product I sold you. You have modified it. So how can now you tell me that it's not safe to be used, it's defective? Okay. Then you have criminal tampering. Now, criminal tampering is usually by employees lah. Okay. Sometimes they could have a vengeance. Okay. Maybe you scolded one of them or told one of them off. So they say, wait lah, wait, I teach you a lesson. So they put in something, maybe a dead cockroach, into one of your crisp packaging while they are packing it, can happen. Okay. Product liability claims. Now, what is the consequences if you have a product liability claim? You will have to pay compensation or damages for pain and suffering, loss of earnings. Okay, if the person cannot work, or you may have to pay medical expenses if the person is injured and stuff like that. Death, okay, incur costs. Legal fees to defend the claim. Recall expenses if you have that cover lah, okay, and your products need to be recalled, then you need to have recall expenses. This is another expense. It's bad reputation for the product. There's price erosion, right? Damage to the market share. That means you have unpredictable financial effects because nobody will buy your product. You cannot secure consumer or distributors who would seek to buy your product. So what will happen? Eventually, your product will deteriorate. The sales of your product will deteriorate and nobody would want to buy the product. So your business will suffer. Other examples, you see, if you're a manufacturer of latex gloves, sometimes the consumers can suffer skin allergy. You see the reddish part there? Okay, continuous exposure to latex gloves can cause this. So you have a claim as a result, latex allergy claim. Screw top claims. Now, this one is a bottle cap. It was defective and the contents or the water got contaminated. So, of course, the people drinking it sued lah. And the claim was paid for about 700 over 1,000. So, this is how claims can occur for product liability. Okay. Any questions so far?
No questions from the chat box, Bala.
Okay, thank you. Okay, can we go for a short 15 minutes break, please? Now it's 10:35, right? So we
It's
come back at
10:35. It's 10:35.
Yeah?
So we shall come back
Hello?
at yes, now it's 10:35, yeah. So 15 minutes break means we'll come back at 10:50.
Yeah,
50.
10:50. Yes, yes, yes.
All right. Thank you very much. All right, yeah.
The training session. Okay, so basically we spoke about product liability. Earlier on, we saw what's the coverage, what are the main exclusions, and stuff like that. We saw some examples. What sort of underwriting information do we need in order to underwrite a product liability policy? Of course, we would like to have a completed proposal form, with full disclosure, because product liability, we usually have to see the distribution. Where are these products distributed? The turnover, okay, and a lot of other details, like which countries they are distributed to and all that. Then, of course, we need the details of claims, product catalog or description. So what does your product do? Or what is it good for? Okay. However, for new products, okay, if it's existingly in the market already, it's okay. Okay, but if it is new, then we will request for the relevant approvals from the authorities. Okay, because certain products lah, whether is food products or whatever products that you're selling in the market, there are authorities that would require uh, you would require to get approvals from before you start selling a new product in the market. Okay, so we will ask for the relevant approvals lah, okay, from the respective authorities. What are our non-preferred risks? Animal feeds, fertilizers, insecticides, crop spray, fumigants, pest, weed control products, all these are hazardous. So we don't write all these. Explosive, fireworks, flammable gas, volatile petroleum products also we don't write. Drugs, medicine, pharmaceutical products and medical equipment, ready-mix concrete, and free prefabricated elements for construction purposes, automobiles, watercraft, aircraft, motorcycles, bicycles, all these we don't write. Okay. Asbestos related products, we don't write. Product exported to USA, Canada. Okay, products exported to USA, Canada. If it is less than 10% of the turnover, total turnover, then we can write it. Okay. As I mentioned earlier, products guarantee, recall, all this we don't do. Okay. Products integrity impairment also we don't do. Tires is another one which we not our preferred risk. Toys or children related products. Now, toys also is another product which I wouldn't say we don't write, but we do it very carefully because the children's toys, you know lah, sometimes the dyes used in some is very colorful. So sometimes the dyes used in some products are the cheap quality dyes, which is toxic. You know, children are like the blocks and all that, although they are big, the parts are big, they love to put in the mouth, you know, and then you can see sometimes the is cheap products, the dye can come off, can stick to the fingers. Okay, so it's toxic. So the child can have poisoning. So we are very careful when we write toys or anything to do with children. Okay. Okay. Unlike motor or property, I know it's very tough to sell liability products. Like for example, lawyers, doctors is easy to sell because the government in Malaysia has made it compulsory that doctors and lawyers must buy insurance, compulsory. Okay. But for other categories of professionals and also like products and all that, right? It's not compulsory. So unlike your motor insurance, which is compulsory, your property insurance, okay, fire insurance, all these people will definitely buy. Okay. Because although not compulsory, it is crucial for your business. Okay. Now, another thing is there's very not much awareness of the product, liability products. That's why the cover is low. Because firstly, not compulsory. Second, people are not aware, lack of awareness. Okay. So obviously they won't buy lah, right? No push factor for them to buy. So what we are trying to do here is to create more opportunity, more awareness of the product through training, presentation, claims experience, so that um, you when you sell, go and see your client, you know, you can talk to them, explain to them and sell. Okay. You don't actually have to find new clients. Your existing clientele, tap into your existing clientele. I'm sure if they are manufacturer, retailer, hey, do you have a product liability policy? Yeah. You know? Yeah. Use this insurance to leverage to get into other classes. Or if you currently have other classes, then just ask them, would you be interested? Maybe they may not be interested today. Maybe 2 months' time, they may be interested. Or some may not even be aware. So when you highlight this to them, they say, oh, there's such thing. You know? Yeah, that kind of a thing. Okay. So at least make them aware that there are insurance protection available for certain products. Okay. So that's the end of product liability insurance. Is there anybody not sure of anything or want to clarify anything from this morning's presentation on professional indemnity and also product liability before we move on to comprehensive general liability. Any questions?
There's no questions from the chat box, yeah, Mala.
Okay, thank you.
Perhaps
Yeah, thank you.
anybody wanted to, yeah.
Anybody want to ask also can unmute your mic and ask. Just ask. No problem. Okay, if there's no questions, then I believe everybody is clear. Let's move on to comprehensive general liability. Okay, similar to product liability, this product is a tangible item, right? You can see the product. Now, CGL does not cover a product, covers a services provided. Okay, services is like uh, whatever service lah in relation to your business. That is what comprehensive general liability will cover. So basically, right, CGL, okay, let's talk about how it evolved first lah. CGL basically it protects your business, okay, from financial loss if you're liable for bodily injury or property damage caused by your services or your business operation. Okay, so if you are say you have your business, say you are okay lah, operating from home, you have a small business lah, part time, you bake your own cookies and you sell during festive season. So in your house, you actually got a small room for this, and your customers, like your customers will be your neighbor, your relative, your friends, come to buy, right? They can come into your home, into the room to look at the cookies first before they choose which one they want to buy. Okay. Now, if you have operating a business like this in your home, don't you think you owe the public a duty to take care when they come to your premise, right? So basically, anyone who comes in, maybe they trip and fall, right? How? They will sue you, you know. So you need to buy a liability policy. Now, if it's a small business, say you're operating like in your home, public liability is sufficient already. Okay, so basically you need a liability policy. You need to have a liability policy. If members of the public or your clients or customers or visitors come onto your premises in relation to your business. Okay, could be your supplier, could be anybody. Okay, so even if you run a home business and customer visits you, you should have a public liability. Maybe not a big limit lah. I won't ask you to buy 1 million, 2 million, 5 million, you don't know lah. Have a small limit policy because you never know, right? Originally, there was public liability policy. And then because, the telecommunication and oil and gas industry was expanding, they required their contractors to have a public liability policy with a contractual liability extension. Okay, now, so if as time went by, because of this requirement, public liability became more comprehensive. Okay, there was a situation now if oil and gas contractor or telecommunications, then they need to include the contractual liability into the policy. Because why? Because this was required by those in those particular sectors due to contractual requirements, which means the principals require them to have this because they will not issue a letter of award. They enter a contract or terms and conditions. So they want this to be covered under the policy. Okay, so this is how public liability was being extended to cover contractual liability. Then at a certain point, they decided, okay, let's come up with another policy, comprehensive general liability. So your comprehensive general liability is actually an extension, a sort of a similar, it's similar cover actually to public liability. That's why I say you can relate better. Okay. So only thing is there are some extensions provided upon request in a CGL, whereby in your PL you don't have it. Okay. So imagine if you're running a small cookie business in your home, somebody comes, trip and fall, you don't have a policy and they sue you, you have to pay the claim and defend yourself. It can be very expensive because you're just operating a small cookie business in the house. How much money can you make from it? Can you enough to defend a claim? I don't think so. So this is why it's important lah. Okay, that you have a small policy at least if you're running a business and public can access to your premise. Okay, this is giant hypermarket. They sell all kinds of things, right? From you name it lah. I don't have to tell you lah. Okay, they sell all kinds of things. Food, some their house brands, some other brands, all kinds of goods, right? Food stuff, whatever, bakery. Sometimes got bakery also operating there. So customers got, or the public have access, can come into the supermarket to buy whatever they want. So the trip and fall type of policy, right? Public liability will be sufficient lah. But they also sell product, right? So they would want to cover both exposures. So in this kind of scenario, they will buy a public plus a product liability, which is called a comprehensive general liability policy. Okay? A combination of both public and product. Okay? Or you could have a contractor, okay? They want to go, okay lah, not contractor. Say the cuckoo water filter people. Okay, you buy a water filter. So they want to go and install in your house. So they will probably buy a public liability public product and completed operations. Why? Because there's installation work at the buyer's premises. So in the event of a claim, this policy will cover. So you can see there are many names it's called: comprehensive general liability or broad form liability. All these are similar coverage. Only difference is whether it covers public liability, product liability, and completed operations, or is it just public and product? Depending on the business of the insured. So liability cover is essential for all business owners. Okay, like for example, a public liability is more of a premise risk, which means like office, small buildings, short lot, you will buy a public liability policy. All right, because it's open to the public, anybody can come in to your shop. Okay, so in a setup like this, you will see that there are various policies involved. You have your property, right? Your fire, con loss, plate glass, all these policies, burglary lah, money lah, machinery breakdown, right? All these policies. So similarly, just like your general classes, your liability also, there are various policies covering different types of exposures. Like public liability is for premise risk. Comprehensive general liability is more for the services that you're providing. Okay. Product liability, which we already looked at earlier this morning. Product liability covers any third-party bodily injury or property damage caused by a defective product that you are selling. And likewise, professional indemnity covers the professional services that you are providing, meaning if you have breached any error or omission committed as a result of professional negligence will be covered by the professional indemnity policy. So I hope you can see a clearer picture on the different types of liability exposures provided by the various policies. Okay. Now, manpower on the other hand, you have your GPA, GTL, GHS, then you have your EL, WC, all these things. So you can see the exposure is huge. Okay, when you're running a business and the various types of policies that are available. Okay. This is a bit boring because I have to go through the insuring clause of the policy to for better understanding. Now, for CGL, as I said, it is similar to a public liability policy. Only difference being sometimes CGL may be on occurrence or claims made basis. Now, the company will indemnify the insured. You will see this word indemnify on most of the liability policies. Why? Because when the third party claim, the policy will indemnify you to put you back to the situation you were in prior to the loss or damage. Okay? So the company will indemnify the insured against all sums which the insured shall become legally liable. So you must be legally liable to pay in respect of accidental bodily injury, including death or illness to any person, and accidental loss or damage to property. Now, happening during the period of insurance and caused in the course of the business or occupation within the territorial limits. Okay, wait, I will go through all those highlighted bold terms, okay, because they have a meaning. All costs and expenses of litigation incurred with the written consent of the company. So it pays you in short lah, okay. It covers just like product liability, third party bodily injury, property damage plus costs and expenses in litigation. Okay. Now, so to indemnify means what? To put back the insured to the same position before a loss happened. That means if you have a car accident, you suffer injury. So your compensation will be paid accordingly for your medical bill, your treatment, your pain and suffering, all these things to put you back to the same position you were before the loss. Legally liable, that means you must prove negligence on the part of, there must be negligence on the part of the insured. That means the insured owe you a duty of care. Like I said, you go to the insured's premises to buy something, right? And the floor is wet, you trip and fall. You can sue the insured for your injuries sustained. Okay. Then damages. Damages, of course, we all know lah, the injury sustained. Or if you have suffered, say you fell down when you went into the supermarket, you tripped and fell because the floor was wet. There was no signage displayed to say the floor is wet. Please take precaution. So when you fell, your watch also broke. So you have your watch is property damage, right? So you can claim for both your injuries as well as your damage to the watch. Okay. Generally, there are two types of damages: special damages and general damages. Special damages are those damages that can be quantified. Okay, that means like your medical expenses, you can have bills, right, for whatever you incurred. Then general damages is those damages that you cannot quantify. For example, pain and suffering, okay, or loss of future earning, loss of you need future care, you need to, for the next few months you need to have care. You cannot walk on your own, that kind of things. Okay, so general damages is those damages that you cannot quantify. Special damages are damages that you can quantify, okay, and substantiate with bills. All right. Bodily injury, of course, bodily injury means death, injury, illness due to negligence arising out of the insured's business. Now, loss of or damage to property means actual or physical damage to third party property. Period of insurance means the term or the duration of the policy lah. Okay. In the course of business, like all other policies, just like your professional indemnity, your product liability, all this, right? The business or occupation or activities carried out must be in relation to the business of the insured. It cannot be because of some other thing lah. All right. Territorial limits means the location where the premises of business activities of the insured is located. Limit, of course, can be any one claim and unlimited, or can be aggregate. Now, I'm not sure whether maybe I should explain to you what's the difference. For claims made policy, usually it is on the aggregate. Okay, like professional indemnity and product liability, you will see that the limit is, for example, 1 million any one claim and in the aggregate. That means the maximum cover you have, the maximum limit you have in any 1 year is 1 million. And you cannot reinstate a midterm. Say you have a claim last month, your policy limit is 1 million. Okay, I have a claim, I already claimed 500,000 already. So remaining my policy limit 500,000, I claim already another 500,000 is left. I cannot reinstate it back to 1 million, It's not like fire, you can, or your motor you can reinstate, right? Cannot. Motor can, I'm not sure. Motor, I'm not sure, but fire I know can reinstate. Okay, so it's like that. Your windscreen you can reinstate if you have a claim. Okay. Now, for comprehensive general liability, okay, if it is an occurrence basis policy, like your PL and all, you can see like it'll be 1 million, any one claim and unlimited. That means there's no cap on the aggregate. Okay, it's unlimited. So you can have multiple claims in any given year. You can have 1 million, 1 million, 1 million, 5 claims in a year also can. Insurer will pay because there's no aggregate cap on the limit. But if you see the word aggregate, then be mindful that's the maximum for the 12 months. Okay. Excess deductible, this must be borne by the insured. Excess or deductible is first borne by the insured, then only the policy will pay the remaining. Cost and expenses of litigation, this is self-explanatory lah. This one is the cost and expenses incurred when you want to, when somebody sues you and you want to defend the claim. So, in a nutshell, CGL, what does it cover? Covers bodily injury, customers who visit you, vendors, visitors to the premises. It can come from any one of these people. Okay. So, what else? Property damage, contractual liability. Okay, contractual liability, I want to discuss further later. I will explain further. So basically, bodily injury, property damage, defense costs and expenses. Okay, these are the main coverage. Defense costs and expenses, meaning there's a legal suit and we have to appoint lawyers or adjusters to assess the loss. Okay. As I mentioned earlier, CGL, there's two forms of policy available. One is an occurrence form. Occurrence form, I think you all know, right? You all are familiar. The event giving rise to the claim should have occurred during the period of insurance, right? The incident, the accident must have happened during the period of insurance, and insurer will respond to the claim irrespective when you report. Now, for claims made, it's not like that. A few things need to be present. Firstly, the act or error must be committed after the retroactive date. Claim must be made and notified to the insurer during the policy period. Okay, so for CGL, unlike product liability and professional indemnity, I said that we only write it on claims made basis, right? D&O also is on claims made. Directors and officers liability also on claims made basis. Okay, there are two forms available: occurrence form and claims made for CGL. Okay, D&O, PI, and product, there's only one form, which is claims made basis. Okay, any questions so far?
No questions from the chat, Mala?
Okay, thank you. Okay, let's move on then. Let's see what are the optional extensions available. Optional extensions, and that means it's not automatically given. It's only given if there's any contract requirement or whatever it is. Okay, so these are optional extensions. Comprehensive automobile liability for third party for third party property damage. Okay, now this extension is over and above the liability that's provided under the motor policy for third party property damage, which is actually I think the cap is 3 million. Okay, so this one is over and above that, but so far we don't see any claim under this because so far third party property damage, the motor policy is sufficient already. 3 million is very huge. I haven't come across any claims which have exceeded that threshold. Okay, care, custody, control. Now, CCC. Okay, CCC, usually it is a standard exclusion. Even under PL, is a standard exclusion. Okay, but if the insured is in care, custody, and control of a particular premises, say they are doing repairs in some office, okay, and or maybe they are okay. A better example would be a car workshop, motor workshop. Okay, say I'm a motor workshop operating, repairing people's car, customers' car. So my employee drives the car after repair, parks it within my compound now. Okay, but while he's maneuvering the car to park, he knocks into another third party vehicle which is parked nearby. So the owner is going to be sued. Owner is going to sue you, right? Yeah. So this is where if you have this care custody control extension, then it will cover whatever claims arising. Okay. But usually this will be a standard exclusion. Now, this usually takes effect where insured does not own the property. That means they are actually uh, in control of third party's properties. Okay, so it refers to a property while it is within your control. Okay, now contractual liability. Okay, contractual liability. This one, I think a lot of people get confused with this because contractual liability, people assume that when you have this contractual liability extension in an insurance policy and you have actually entered into a contract with your principal, it covers everything that is stated in the contract. That is the impression of most people. Okay, now that assumption is not correct, is incorrect, because your contract may have a lot of terms and conditions, warranties, right? Let me give an example. Okay, you may enter into a contract and one of the clauses may be, what is the penalty for delays if you delay the project, completion of the project? So every week I'm going to charge you something, some penalty for delay. This will not be covered under your policy. So be mindful. Not everything that is contained in the contract will be covered by the policy. There's the policy will only cover you for what? We went through the insuring clause. Policy will indemnify you if you are legally liable, okay, for bodily injury or property damage in the course of your business. Okay, not for everything that you sign on the agreement or the contract. So please be mindful. Don't think that if I got contractual liability, then everything I enter into contract with the principal, if I don't comply, then if there's a claim, I can claim indemnity. No, doesn't work that way. Okay. Because you see, if you look closely, the contractual liability clause will always say, right, provided always that this policy, sorry, it will always say, right, it will cover such uh, claims, but such exclusion would not apply to any claim where liability would have attached in the absence of such warranty, guarantee, indemnity, or other contractual obligation. So usually, even if you have this contractual liability or you don't have it, if there is a duty owed and the duty has been breached by the insured, you will be compensated. Okay, so it does not mean that everything is covered. Damage to principal existing property. This is also another standard exclusion under the CGL. So when you have this extension, this policy then will be extended to include insured's legal liability for damage or third-party property damage owned by principal, okay, as a result of whether there's any act or error committed by the insured. Say damage to principal's existing properties, like say they are doing some work lah, okay, in the office, construction work, okay, and the property, if there's any damage caused to the property that they are working on, okay, this will not be covered. Property work upon, okay, this will not be covered. But if they damage any other property and the damage is not due to the principal's fault, okay, then the policy will cover if you have this extension. Okay. Sudden accidental pollution. This one will be, pollution will be covered, can be covered lah by way of extension. Cross liability. Now, cross liability, how it works is that if the policy has more than one insured named, okay, so we assume that each of the parties, for the purposes of this, the insurance, have a separate policy. Okay, so they can actually, they are treated legally, they are treated as having separate policy. And usually in this kind of situation, we will waive the rights of subrogation. So meaning, if A and B are insured under a policy and we have this cross liability clause, we will remove we will waive the rights of subrogation, so that if A is at fault, we pay the claim, we won't subrogate against B. Okay, waiver of cross liability clause. And subrogation means that once GE pays a claim, GE can step into the shoes of the insured and go after the third party that was negligent. Okay, so usually we will step into the shoes of the insured and go after the party that was negligent and recover whatever we can recover. So if, for example, if there's an additional insured, more than one insured named in the policy, like what I said just now, we will waive the right of subrogation, which means we will not subrogate, recover from the party named under the schedule, the other additional insured or whatever it is. Okay. Okay. Public liability. Public liability, you all are more expert than me lah, huh? And I have mentioned a few clauses here, but this list is non-exhaustive lah. These are the main extensions. Say food and drinks poisoning clause. Now, this one is if you're operating, say, a restaurant, maybe. So you buy public liability, then you extend it to include food and drinks poisoning. Why? Because you serve food, you prepare and serve food. People can sue you if they suffer food poisoning, right? Your meat not fresh lah, all these, they can say your prawn not fresh, the people eat it and then they can suffer food poisoning. So they will sue you as a result. So if you open up a restaurant, operating a makan shop, you need to buy public liability with this extension. Temporary visit overseas clause. This one is for certain individuals, high-ranking individuals in the company who go overseas on company trips. Loss notification clause, alterations, repair clause, flood, fumes, water pollution clause, neon advertising sign clause, contractors, contractors, subcontractors also under PL, okay, can be extended. Canteen clause, say you're a employer, you provide food for your employees during break. You operate like a small canteen. Okay. So yeah, you have the canteen clause. Work away risk. Now, say you are a small business operator, you operate a small aircon business lah. Okay, you go and service aircons. Okay, GE office, right? You come and service the aircon. So you will need to buy a public liability policy and you extend it to cover the work away risk, because your risk, you don't have third party coming to your premises. But what do your consultants do? Huh? They go to the client's place, customer's place, to do the maintenance work or servicing. Okay, so that's where you need public liability to be extended to include work away risk. Defective sanitary installation clause, fire explosion clause, false arrest, all these are standard clauses lah. And then first aid. Okay, so these are all the auto extensions that can be granted under a public liability policy. Nowadays, you see some of the clauses that are granted under a public liability policy, people don't think lah whether is it relevant or not, because some of the policies we see, we think, oh, is this clause relevant to this business? Why they extend this? Okay, so basically, please look at it properly lah. Is it relevant or not? You know, don't simply for the sake of, because your competitor is giving most of the time, yeah lah, we ask them, why do you need this? Then they say, oh, competitor giving so if I don't give then the insured will ask, will compare. Okay, this is the normal reply. So you need to educate your clients also lah. Okay, what are the main exclusions under CGL? Okay, ownership, maintenance, operation, use, loading, unloading of automobiles, aircraft, all these mobile equipment used in racing, speed, demolition contest, or stunting activity not covered. Watercraft, vessel, operated, rented by insured not covered. Liability arising out of professional services, okay, is not covered. Professional services is covered under professional indemnity policy. Product liability, guarantee, recall is not covered under this policy. Why? Because you have your product liability policy to cover. Then pure financial loss, loss of goodwill, loss of market share, all this not covered under the policy. Liability assumed by insured under any contract or agreement. This is the contractual liability extension. Example, if there's penalties imposed for non-completion or delay of a project, this policy will not pay. Okay, so again, I repeat, the policy with the contractual liability extension, it does not mean that the policy will pay any claims, all claims in relation to the if the contract is breached. Okay, so please be mindful of this. It doesn't cover everything. Okay, we still have to go back to the insuring clause. So any claims in relation to fine, penalties, punitive, aggravated, exemplary damages will not be covered. Bodily injury to insured employees arising out of and in the course of employment. Why? Because this will be covered under a employer's liability or workman compensation policy. Then, of course, pollution and waiver of subrogation. Okay, these are main exclusions. Why waiver of subrogation? Because we will want to always subrogate our rights and recover whatever we can from the party at fault. What are some examples of businesses that operate which require CGL? Supermarket, hypermarket, shopping mall, restaurant, hotel. Hotel also nowadays, they got a lot of restaurants in the hotel where they prepare food and serve. So that's why PL, public liability, and product liability becomes a necessary. necessity. Industrial manufacturing factory, contractors performing installation maintenance services, oil and gas maintenance contractors. Okay, these are some of the categories of businesses that require CGL cover. Any questions so far before we go on to the claims examples?
No questions from a chat box, yeah?
Okay. So let's look at a few claim examples just to give you all an idea. Bodily injury. You can see in the picture there, the contractor is servicing the aircon at client's place. Okay. Assuming one of the tools fall and hit the client's employee's head, what will happen? The employee will sue this aircon service contractor, right? So he needs to buy a PL with an extension to cover work away risk because he's going to client's place to service the aircon. Okay. Property damage. The other guy is cleaning windows. So he's cleaning windows in the client's office. Accidentally, his equipment dropped on the client's glass table and broke the table. So the client is going to sue him again. They have to buy PL with work away risk extension in order to cover this type of losses. These are some other examples generally, okay, as to how a claim can come about. Restaurant employee mopped the floor, forgot to put up a caution sign. You can see your supermarket floor, all this, right, or your sundry shop. Early morning, if you go very early, then they will be mopping the floor and all this. So by right, uh, they have to put up a signage to say, uh, you know, warn customers of the wet floor. Okay. Otherwise, if there's no signage, the customer walks in and then falls down and has an injury, then you have to entertain that claim. An overhanging lamp in a boutique falls on the head of a shopping customer, causes injury. This scenario also, they can actually sue the shop owner. A plumber, your kitchen sink got problem, you call the plumber, is stuck. Okay, a plumber comes, then he brings a high power tool, a drill. Then don't know what he did, drill here, drill there. Then he caused damage to your property, home. So you can sue them. You're not going to keep quiet, right? Or the plumber come and make things worse. Then those delivery personnel, installers, handyman working with clients' office accidentally say knock over and damage an antique item. This also is claimable under the policy because they have damaged it. Let's look at some of the decline risks. Oil and gas company, okay, involved in drilling, producing, exploration, refining, or distribution work. So any oil and gas related activity which is offshore, involved in drilling, exploration, all these we cannot do. Okay. Terminal operators liability and ocean marine liability. This one is more like the port authorities lah. Okay. All those port authorities like Westport, okay, Kuantan Port, Penang Port, all this we cannot insure. Okay. Shipbuilding, ship repairing, and ship breaking yards. We cannot write this risk. Owners or operators of railway, trams, cable car, chairlift and all that we cannot do. Owners, operators of stadium, amusement park, theme parks. Okay, stadium. Why underwriters don't like this stadium risk? Because in a stadium, okay lah, stadium usually can contain, or the capacity is huge. Okay, um, they can contain up to 40, 50, 80,000 people also. Okay, and you know that in a stadium, the entrances and the exits are limited. And then there's a lot of, it's normally very dimly, it's normally very dim lighting. Okay, and it's got a lot of staircase here and there, and then like rows and rows for people to sit. So in the event there's any event held in the stadium, okay, and the stadium is full or whatever, right? Can you imagine if there's any disaster, say like an explosion? What will happen? I tell you, there will be a stampede. People will step on each other, push them, push down, whatever, and run helter skelter to escape. And there will really be, you know, um, a lot of emergencies lah, unwanted emergencies lah, so to speak. Okay, so please be mindful of this. That's why we don't like to ride stadiums. Ownership or operators of waste disposal sites. Okay, now waste disposal sites are like those who operate like DBKL, Alam Flora, all this. We don't like to do all this. We cannot do. Okay, not we don't like to do. We cannot do. It's decline risk. Contractors engage in 100% wrecking and demolition work. Also, we cannot do unless it is something that is incidental lah. Okay, and contractors engage in construction or maintenance or dismantling of bridges, tunnels, okay, exceeding 50 meters in length, and dams or whatever. This one we can cover. Sorry, this one we cannot cover. We don't like to do. Okay, because it's very high risk. When you are doing bridges and dams and all that. Okay. What's the underwriting information required? Now for CGL mainly, there's actually most of the time there's no proposal form lah for CGL. Okay, most of the time, um, we don't ask for proposal form. Okay, because nobody nowadays asks for proposal form, but some risks we do ask lah. Okay, for better understanding. Then at least we know what is the exposure, what's the insured doing. So if you can't provide a proposal form, the minimum information we need from you is at least tell us who's the insured, what sort of business they do, okay, what limit, what is the scope of works, where is the risk located, okay, the turnover, claims experience. If it is a project risk, then of course we need the insurance article, letter of award, and we also need the scope of works. So these are some of the information that we require for CGL. Now for CGL, the premium, sometimes people ask, how are y'all underwrite? Yeah, it is driven by several factors. It's not just the limit or the turnover. It is a combination, okay, of what limit you buy. What is the deductible or excess you are prepared to carry? What's the contract value? Period of cover? What's the risk exposure? Your scope of works, basically. Okay, and then also your claims experience lah. Okay, and then finally is also market forces, competition. Okay. Okay, any questions? We have actually come to the end of the presentation. So anyone has any questions to ask or any clarification that you need? Alex, any questions in the chat box?
No questions from the chat box, yeah. As Mala mentions, yeah, so anybody has any questions, you may feel free to unmute yourself, yeah, and to raise your questions to Mala, because of experience, head of liability, yeah, he's able to answer you the practical questions that sometimes you face and you start don't know how to move on, yeah, when you're dealing with customers, yeah. So feel free to unmute your mic because this is your Penang sessions, all right. Um, just raise any questions, you know, for the benefits of everybody that has joined in these sessions. Yeah. Anybody wanted to raise any questions? This one seems to be quite a quiet group. Yeah. All right.
Yeah,
So if
very quiet.
there's no yeah lah. So if there's no questions, what we will do? Yeah. Thank you, Mala, for wonderful sessions for this morning, especially arranged for Penang branch agents. Yeah. And for the agents, please stay tuned because we're going to launch the poll right now. All right, via Slido. You need to actually complete this poll here before you leave the meetings room here. So give me some. Let's see. Where is it? Okay, give me some
Okay,
time for me to retrieve to launch the poll here. Yeah.
okay, in the meantime, I just want to thank everybody for your attention and your time this morning. Okay, I hope you benefited from the training session. Um, hope to see you on, hope to, see you on other training sessions. Thank you very much. Over to you, Alex.
Yeah.
Yeah,
Yeah. Thank you a lot. Thank you to you, Mala. Yeah. All right.
thanks. Yeah, okay, welcome.
So while doing polling, just a friendly reminder, yeah, as I mentioned in the morning during the what do you call that, the market conduct reminder, that we have this six e-learning need to be completed by both the new agents and existing agents. Now, for new agents, you will need to complete it 6 months within your appointment date, yeah, and for your this existing agents, yeah, you need to complete it by end of the year. Otherwise, then your front end system will be blocked to issue new policies. At the same time, also you can earn the CPD. Yeah, of course. Nevertheless, I will say that yeah, for those agents that with the dual license agents, that means with GELM and GEGM, if you have completed those six mandatory from the GELM, yeah, e-learning, then you may skip or get exempted from GEGM. However, if you want to have a refresher and earn CPD, you feel free to do so. All right. Uh, Please do not wait until last minute. Very important because there could be technical issue that we will not know or foresee. Do it right now, progressively. Yeah, if 1 month you do two e-learning, by 3 months you have completed the six e-learning already. All right. Also for the benefit of your the knowledge. For new agents, again, to be reminded that if you have not attended the ETP, the onboarding training, please do so. Yeah, because you are only given 6 months to complete the onboarding training, right? Otherwise, you will be terminated. All right. A very cautious word here. Please take note. Yeah. And for those agents that perhaps that your friends just joined you as the new agents, please give them a reminder. Yeah. To attend the ETP. provide our onboarding training. Thank you very much, everybody. Hope you have a wonderful sessions gathering, as well as has actually have